Good morning and welcome to the IOSH Magazine webinar. I'm Louis Worsterman, IOSH Magazine editor. We're here today to discuss the sentencing guidelines for health and safety offences in England and Wales, the biggest development in the law in this area since the corporate manslaughter legislation came in 2008. I'm very pleased to have with me in the studio two expert guests, who, if you would introduce yourselves, gentlemen.
Hello, I'm Michael Appleby. I'm a health and safety lawyer. I represent companies and individuals who are being prosecuted for health and safety offences or investigated for them.
Hello, I'm Simon Joyston-Bechal, Turnstone Law. I'm also a health and safety criminal defence lawyer acting for companies, directors facing investigation and prosecution on health and safety matters, and also training boards of directors and trying to help companies avoid the accidents or make it less likely that if there is an accident they'll be prosecuted. So those are the legal preventive measures on the health and safety side.
Thanks very much. So today we'll go through the basics of the new guidelines and then their implications for businesses of different sizes. We'll take questions through the webinar and I'll get Simon and Michael to respond to them as and when they become relevant. Any questions that we can't field today, Simon and Michael have very kindly said that they will try and provide written answers to afterwards, as long as there aren't 500 or 600 of them. So, if we start with you, Michael, could you tell us who's most affected by the new guidelines?
Yes, certainly. As the guidelines say, they cover the Health and Safety at Work Act, corporate manslaughter and food safety. So from the Health and Safety at Work Act cases, it's any employer, any organisation that has a business where there's a health and safety risk. And also the sentencing guidelines covers individuals, so that's if you're looking at Section 7 and Section 37 for directors. In terms of corporate manslaughter, as it says, it's the offences under corporate manslaughter. What the guidance doesn't cover is individuals that are prosecuted, say, for gross negligence manslaughter. Also, it doesn't cover offences under the fire safety order. But I suspect, I don't know whether you agree, Simon, if there is a sentence under fire safety order, it's likely to come into play, I would have thought.
I think it would be very difficult for fire cases to avoid following these guidelines.
I think so. And also we've got the food safety, a similar sort of approach to the Health and Safety at Work Act. I think it's fair to say that the reason these guidelines have come about is to try and provide some consistency. That's the aim. And really, if you go back to appeal cases like the Sellafield and Network Rail, which is beginning 2014, very much a push from the Court of Appeal that fines should be higher, particularly for large organisations. So hopefully that covers that very briefly of the people affected.
Thanks very much. Simon, can you explain briefly how they work?
Yes, I'll give it a go. I'll give it a go at explaining it. Can we have the first slide? Oh, you've got that one. Thank you. So essentially what they're trying to do sounds very rational. It is, if you were to try and plan what could be a set of rules for determining how big a punishment should be for a health and safety breach, you'd probably come up with something similar to this. And it's a very attractive idea that does look very logical, although I might indicate a bit later why I think it is fundamentally flawed. But let's just, so the starting point is, each case, we're coming up for sentencing, the judge will decide on a culpability factor. How culpable was the offender? And there's a slide come up there, but please don't, you need to look at all the little details. If you can see the headings, this is really the important thing. So was your culpability very high, high, medium or low? And that's going to take us through another series of stages, into a table, and from the table the judge will read off how big the punishment should be. So that all looks very sensible indeed. Culpability factor is the first one. The next slide shows the next factor, which is a matrix, and fortunately in the health and safety world people are used to looking at a matrix and working out how it works. So this matrix is going to decide upon a harm category, The harm categories have numbers from 1 to 4. Once again, the little details in the slide, if you can't see them, not that important. So in order to decide how big your harm was on a category of 1 to 4, the judge will have to look at, on the left-hand side of this table, the likelihood of harm. How likely was it you were going to create a harm? And that's on a scale of high, medium or low. Sounds very sensible, although no one really knows what high, medium or low likelihood are, which is another criticism. And then on the top of the matrix, we're going to look at seriousness of harm risked. So if you've risked a very serious harm, death or disability, you're in the left-hand side of that box, of that grid. And if you've only risked a more minor injury, you're on the right-hand side of the grid. So by looking at the seriousness of harm risked and the likelihood of harm, we end up with a harm category where 1 is the more serious harm. And then we take that through, we'll see from the next slide, we take that through to a table, which, or there's a series of tables in fact. So we'll have tables for different sizes of turnover of organisation. And this slide shows the table for large turnover organisations. And within each size of turnover of organisation, the judge will plot where is that level of culpability. For that particular culpability, what is the harm category? And then the judge will be taken to a starting point fine. And then from that starting point, the judge can depart up or down within a range. And so the starting point and the range are given on the table. It looks like, one way of looking at it is this is complete madness. It looks like crazy stuff. But then you look at it and you think, okay, I understand that. This is the most sensible way of plotting through the sorts of factors that ought to influence the level of punishment, putting them out in a sensible scale to create, I think, Mike, you said at the beginning, something that's consistent.
Yeah.
And being consistent was very much the aim of this. So that if you have courts, 100 courts across the country, every judge is going to be led through the same recipe to the same table and only allowed to depart in really exceptional circumstances from this rigour. And so a defendant in Cornwall can expect the same sort of punishment for the same sort of breach or bad behaviour as could be expected of a defendant in Lancashire. That sounds like a sensible idea. My fear, as I might explain, is that the apparent attraction of this idea won't actually be borne out, or it struggles to be borne out because of the way the exercise, the details of the exercise.
I should just say that if these slides, if the table slide particularly is a little small on your screen, then it's taken from the guidelines themselves, which if you Google health and safety sentencing guidelines will come up first in Google, and the table is in there. That top line fine, maximum fine is 10 million, just for anyone who's looking at it at the moment.
Yeah. Top right corner is 10 million. So if you're a 50 million pound turnover company and you're in the highest culpability section with the highest harm category, then you can expect a fine of up to £10 million. That's the idea. And
but having said that, it does say at the top for if your turnover is well in excess of that,
we'll come back to the sky. Why the sky is the limit at some point.
Fair, and if you're in the very low, if you're in the lowest of the turnover tables with a low culpability offence with low harm category, there are some fines of, I don't know what it is. It's it even goes a £200 starting point with a range of £50 upwards. But you'll be very lucky to be in those categories for reasons we might come to. Can I explain that when the Sentencing Council created these tables, the intention was to increase the level of fines across the board for health and safety, as you said, Mike. Yeah. And the other intention was to do that more for the larger companies who are perceived as having got off light in the old regime. Yeah. So that was the plan. This should be a more serious regime with bigger punishments. And the Court of Appeal in an important case last year said very much the same thing, that for the biggest turnover companies, for the most serious crimes, serious health and safety crimes, the punishments should be similar to the sorts of punishments they could expect for financial misdemeanours in the banking world and rigging markets and all this sort of thing, upwards of £100 million. So it does fit together with this idea of more serious punishments for health and safety offences. That was intended.
Sure. The inspectors have always decided whether or not to bring prosecutions based on potential for harm, but it's not something that's been explicit in court guidelines on sentencing before, but it does turn up in the new guidelines. Could you say something about that, Simon?
Yes. Okay, if we have, let's have the next slide, and then we'll show that. Okay, so in the criminal offences under Health and Safety at Work Act are to do with exposing people to risk, not really whether you've created a harm or not. It's just exposing people to risk. And except for the manslaughter offences where you have to have a death, exposure to risk is enough.
So the harm is the evidence of the breach.
So in the old world, offences, prosecutions and punishments tended to be linked to outcomes. It wasn't always right, and it wasn't always fair, and it didn't always happen. But it tended to be that if you've got a more serious accident, you're going to be more likely to be prosecuted and you're going to get a bigger punishment. And we kind of knew where we were with that. So if I give an example of a fall from height, imagine you've got an unprotected ledge in your premises, which people could fall off. It might be unprotected because the railing is loose or there isn't a railing. Now, imagine nobody's been injured, but an inspector comes in and finds this unprotected ledge. At that point, no harm, no risk. You can still have committed an offence of exposing people to risk. Imagine someone falls off and breaks an ankle, or imagine someone falls off and they break their neck and they're paralysed. So 3 situations: no injury, just risk; small injury, big injury. In the old days, before this stuff came in February this year, you would expect that the way the prosecution went and the way the punishments went would be quite closely linked to what was the eventuality. So yes, you could still be prosecuted for exposing people to risk, but you might get a £10,000, £20,000 fine. Someone's fallen off and broken an ankle, maybe a £20,000, £30,000 fine. Someone's fallen off and been paralysed, maybe a £300,000 fine. But we would have been able to tell last year, and Mike and I, within £100,000 or within 50% of each other, we'd have been pretty kind of clear as to where this case was going. The new world under these guidelines, if we look at this table, says no, we don't treat the cases differently depending on outcome. We look at the risk. So in all those 3 cases, we're going to be asking ourselves, what's the likelihood of harm? What's the likelihood someone would have fallen off that ledge, high, medium or low? And if they did fall off, what harm is risked? And if they're risked, because the ledge is, for the sake of argument, 3 meters high, if they've risked fatality or paralysis, they're in the most serious category, even if no one fell off. Mm-hmm. So you are brought, so on the one hand you might say this is really fair, this is really good. This is because frankly the 2 premises owners, one who owns a premises with a loose railing and no one falls off, another owns a premises with a loose railing, someone falls off to their death. They've committed the same breach, they should be punished in the same way, and you can argue that, and I think that was argued. But it makes it much harder because we're all left scratching our heads wondering, in all cases, what was the harm risk, because there hasn't been an accident of that nature, and how big was the risk? So this is how the new world works. We look at risk and we treat all of those 3 cases more or less the same because we've breached and we've exposed people to a serious risk. There is, the effect of that is that the old cases that would have been a £20,000 fine because there's no serious injury are now going to be sucked up to being what would have been in the old money the £300,000 fine because you risked a death. But because there's been an inflation that was intended, £300,000 has now turned into, for the sake of argument, 3 million, depending upon your turnover. What was a case that would have been a £20,000 fine when no one's been injured now becomes a £3 million fine. So that's the sort of thing. But in a sense, what we've got, and this is the important thing to understand, is that all the cases get sucked to the higher level because we're focusing on harm risked. Now you might say, well, that's fine, that's fair. But when they did that exercise of moving from 300,000 to 3 million, saying we want to increase the penalties, they didn't, and I know this because I know it from the person who's drafted it, I've asked this question, they didn't say, but we've got to reduce that because we're going to be sucking all the cases up. Because even if there's a risk but no eventuality of a serious incident, we get sucked up. They didn't take that into account. So we have an extra inflationary pressure that all the smaller cases get sucked into the bigger cases. So that's one, what I would call an extra inflationary aspect. The other is that if you've exposed more than one person to harm, then you get jumped up a category. In this table here, if you were going to be on category 3, but you've exposed more than one person to risk, you get jumped up to category 2. So I describe this as another inflationary factor, which on the one hand you might say, well, it's quite sensible, you expose more people to risk, it's a more serious thing. But someone must have had in their mind that there are a lot of people out there with an ordinary health and safety offence that only exposes one person to risk. But I've never seen a case where someone's at breach and only expose one person to risk. Because if you've got a ledge people could fall off, there's more than one person who could fall off it. And even if there's only ever going to be one person on that parapet, he could fall off or she could fall off and land on someone and injure them. Or there'll be different people working shifts in that particularly hazardous location. I have struggled to find a scenario where only one person is exposed to risk. So what that means is that because of the way this is drafted, whatever category you're in, you're going to be jumped up a category because you've exposed more than one person to risk. So what we have, if you remember that table with all these different levels of fines, is it all looks perfectly sensible, but it starts to unravel because people get sucked up for having sucked up a category for exposing people to risk. They get sucked up a category because they expose more than one person to risk. So the end result will be more companies and individuals, we can come to in a minute, being brought to the top of the table or the higher levels of the table towards the top right, which is, some people might say, oh, well, that's the reality, that's fair enough, but it wasn't what was intended. And I think it's an unforeseen consequence of where this takes us.
We've had, the guidelines came in February. We've had a few months of cases, their effect on sentencing, on penalties, was immediate. In fact, there was even an uplift before they came in, as people. It seemed like the court suddenly remembered that there was an existing set of guidelines that they hadn't been looking at before. But Mike, could you talk us through the lessons of the cases that have come through since the guidelines came in?
Certainly. I mean, if we could move on to the next slide. I think it's fair to say that it is very difficult when you look at the cases that have occurred since February, and as you quite rightly say, the cases that occurred soon after the guidance was published, you started seeing that there were some bigger fines coming in. We are still relatively new, and I think it's fair to say the courts are still trying to come to terms with this approach. Because I think the big difference is that whilst Simon and I, as health and safety lawyers, we're used to dealing with risk, you've got to bear in mind the criminal courts, health and safety cases, are a very, very, very small part of what they do. And dealing with risk is really something that they are not used to. So I'm not surprised that what the Sentencing Council intended may not be what is happening. I think the other thing is, I mean, I've just chosen a few cases. I mean, I'm sure if Simon was doing this bit, he might have found a few other ones. I've just taken some representative cases to look at the higher end. But it is very difficult to say exactly what is going on, because most of the reports that you have of these cases come from HSE's own website. And when you do find articles, there may be a certain more detail, but it's still very difficult to look at the fines that are coming out and to understand exactly how that fine has been arrived at, because invariably we don't know the turnover of the company. Obviously, if it's a well-known company, we might know. And what you don't know for sure is the harm category, though you can possibly guess that from the circumstances. The real thing is we don't know what culpability level has been put on there. Anyway, so I've just chosen a few cases, some that are fatalities and some that are not fatalities, just to look at how they have panned out. And the first one I've chosen is Baldwin Crane Hire, which, as you can see, is a case that was came to court. It was sentenced in December of last year, so before the new guidelines were in. But you have a look at it and you think, well, perhaps they've got one eye on there. And this is a man who's driving, he's delivering a crane, and the brakes fail. This is a corporate manslaughter case, and as you can see, the fine there is £700,000. Go on a few months later, and there's the case of Falcon Cranes, which is 2 deaths, and it's the Battersea crane collapse, which I'm sure some of the listeners may remember from 10 years ago, where a crane went over in Battersea. Crane driver was killed, and also a member of the public. You look at that, I think that was a medium-sized company, and there we have, although not a corporate manslaughter case, started out as a corporate manslaughter case, so under the old law, and there you see a fine of £750,000. One thing I think is rather interesting about that case is that the costs that were awarded were £100,000. And I understand that the costs requested from HSE were in excess of £500,000. And so you kind of wonder, was when the judge was looking at, well, I've got to give this big fine, you wonder how that impacted on his views on the costs. And there may, of course, have been other factors. We then go to Travis Perkins, which is a case where a member of the public is trying to put pieces of wood onto his roof rack, falls over, falls backwards and falls into the path of one of Travis Perkins' vehicles. Now, I know there are arguments in that case as was there really causation between the failures on the part of Travis Perkins and the incident itself. But as Simon's been talking about, it's about exposure to risk, and there you see a fine of £2 million, and I think that's far in excess of what we would have expected, not that long ago. Balfour Beatty Utilities. That's a case where it's a trench collapse. Another case that is quite an old case where started off as a corporate manslaughter, and there we see a fine of £2.6 million. Now this is obviously one of many Balfour Beatty cases, and I think it's been reported a lot on in that case where the court was trying to think, well, do we look beyond just the finances of that particular part of the company? I think the reality is, in the end, that was still a substantial, and that led to a £2.6 million fine. But it shows the way in which the courts are now starting to rethink about what are the financial side of things that they can go after. And then, just to finish off with, which is this one of in construction, that's a recent corporate manslaughter case. What I find interesting about that case, it's a case where there's 2 gentlemen have been out for a drink. They have a bit of an argument, and one pushes the other, and he falls against a hoarding, construction. And on the other side is a drop of about 4 metres, and he's killed. The prosecutor talked about, every day 200 school children walked about by this hoarding. So you think, oh well, now he's starting to talk about risk. But when he comes to sentence, he sentences two deaths. He sentences £250,000 for both deaths, making 500, and then £50,000 on top for the health and safety offence. So it's almost as if he's gone back to the old way of looking at how to sentence. So at one point they seem to be looking at risk, and then the other point is going back to the old way of thinking. Well, look at what the consequence was. If we could go to the next slide, which is some sentences, which are of non-fatal incidents. And the first one on there is Sea Row Ports, which is in January of this year, so just before the new guidance came in. But clearly, I mean, this is a case which is about a power capstan, so, something that's used in the port industry for getting ships in. It was seen as a great, thing to stop a lot of the back problems that are in the industry. And a man gets his arm caught in the power capstan. Now, this is, to my knowledge, the first type of accident like this. I mean, power capstans have been used for years and years and years. I can't get to the bottom of how exactly the accident happened. And yet we see a fine here, so it's not, you couldn't say this was a case where death was likely outcome. But here you see a fine for a medium-sized company of 1.8 million, which I think is, took most people by surprise. You've already mentioned the ConocoPhillips one, which is, releases of gas exposure. No one injured. There was, talk that maybe 66 workers could have been put at risk. And here we see a fine, obviously a company with a massive turnover of 3 million. Then we look at McCain Foods, obviously another big, well-known company. There's another case where an engineer who's trying to look at a problem on a machine gets his arm caught, very serious injury. The case is effectively an appropriate guard wasn't on there, and there we see a fine of £800,000, a large fine. Then, it's not just large fines for accidents. There's the next case, which is about hand-arm vibration syndrome. So it's all about vibrating tools and halves. And there we see a fine. I mean, the halves fines, I think, were in the past. You could have thought about £10,000, maybe 20 if it was a large company. But now you see a fine of £200,000.
And this is at a time when the HSE are targeting health.
Much
more than they have done in the past with the resources that they've got for inspection.
Absolutely. And then you look at the last one I got on there, which is Scottish Power, and there you see, a fine of 1.75 million, and that's a very serious scalding, for a faulty valve and steam, coming out. Once again, that is a much higher fine than you would have expected in the past. Two other cases that I think are interesting to look at, which I think gives me concern about whether there is really consistency coming out here, which is, there was two cases, they're not on the slide unfortunately, but, and that concerns British Telecom. We all know British Telecom, a big company, big turnover. They had a case where they were fined at the end of May in relation to falls from height. They had two workers who fell from height using, doing cabling from a ladder. And there you have a fine of 600,000. And it's a case where the company had entered a guilty plea. And as I think we'll be talking about a little bit later, if you enter a guilty plea, then you expect a discount for that guilty plea, and that's set out in the guidance. But go on a few weeks later, they're sentenced in respect of another fall from height where only one person was injured, but this time it was a contested case. So if we're, it's not about looking at what were the actual injuries, looking at what the potential injury was. This was a fall through a ceiling, fall some height. Man survived. Contested case, so there's no reduction, for a guilty plea, and yet that fine was £500,000, so less than the case that they'd been sentenced on a few weeks before, where they had pleaded guilty. So I think that's very interesting, looking at that as a sharp comparison. It makes you wonder, is it in the second case that the judge, having had the trial, perhaps understood the risks and that they were better? I mean, I know he was critical of BT, but I think he does just go to say my concern, which is when you're looking at this, it does require the court to look at risk and to understand risk. And I think that is something that's very new for the courts. It's very difficult for the judges.
And it's very difficult to do. Because
Absolutely.
if you have a guilty plea and you don't have experts in there to decide, if someone's going to fall through a trap door, the trap door, there might be a 6-foot drop. Does the judge know really the likelihood of different types of harm? And there might be a knee-jerk reaction. Well, of course you can die from falling 6 foot. Certainly you can. Okay. So, but what's the likelihood of that happening?
I think the
and
problem
who
is,
makes these decisions? Of course, the reality is you need super experts, and I'm instructing experts, and even for them, it's very difficult to work out. And we struggle, but we use every resource we can with experts and international statistics and tables from employment organizations across the world and all this sort of thing to work out quite what the risk of harm is from different types of scenario. But at the end of the day, I might come to a conclusion with the expert. The risk of harm is 1 in 10. The risk of being paralyzed or killed, 1 in 10, for example. Okay. But then the judge has to say, is that low, medium, or high? Well, 3 judges will say 3 different things about whether it's low, medium, or high. But when we looked at those tables, the difference is going to be, are you going to be fined £100,000 or £10 million? But so this concept that was in the minds of the people who drafted this, that we would have something that was more consistent and reproducible across the country, is just sort of one judge will say, I think 1 in 10, this is an exceptional case. I've actually been told by the experts who agree that the risk is 1 in 10. Now I've got to decide, is that low, medium, or high? 3 judges scratch their heads and come to 3 different answers with 3 totally different fines. But that's an exceptional case. Most of the time, there won't be an expert saying the risk is 1 in 10. You just know he's fallen through a trapdoor 6 foot and could it be fatal? And you're not really supposed to look at the actual injury because that's not really relevant anymore.
But I think, Simon, I think there's always a difficulty in criminal courts in getting expert evidence across, and you know you're at the mercy of your expert as just to how engaging they are. I mean, I think you find a lot of criminal courts, they want to hear evidence, and I think sometimes, and this is I think is the big debate here, is if you've got such a large fine as a prospect, and you feel that you're banging your head up against a brick wall in terms of being able to get across to the prosecutor how you view the risk. And we've all had this, haven't we, Simon, where you get a set of statements through, and it looks terrible because guys, when they're interviewed by anyone in authority, will just want to get out of the room. They answer the questions. And I give you an easy example. You say to the employee, "Have you ever seen this risk assessment?" And he says, "No, I've never seen that risk assessment at all. I've never seen it." That seems terrible. If you then go and ask the same employee, "Have you had a toolbox talk about this?" And he says, "Yes." He's telling the truth in both times. But in terms of how you're managing that risk, 2 different views of that. And I think now the onus is on trying to really look at the evidence that's being presented. And I can see that there will be some companies to say, well, actually, if I'm going to get across to the judge exactly the context of this risk, I may be facing a big fine, but look at the differences as to whether I'm high, low, or medium in terms of culpability. Why don't I have a trial? And I'm not sure that we've been talking about unintended consequences. And I think that is it's going to be a real concern when companies start seeing the really large fines coming out, to think about how they're going to proceed with this. Is it going to be obviously just a guilty plea, trying to give the mitigation? It's very hard to put risk into context. when you haven't heard evidence, when you haven't, and if we could just go to my, sort of next slide, which is everyone knows about Professor Lofsted, and one of the books that he goes on about is Thinking Fast and Slow, and that is by the well-known psychologist Daniel Kahneman. And I think this is a really good quote. He says, we are prone to overestimate how much we understand about the world and to underestimate the role of chance in events. Overconfidence is fed by the illusionary certainty of hindsight. And I think this is so often the problem, is that when we, it's all very well saying we're looking at really what the potential is, and this is all about risk. But when you're there faced with a very serious injury or a death, the immediate reaction is that it must have been a high risk. It must have been a terrible failure.
And that's why I think part of the error here that these guidelines fall into is to think that it is more consistent and fair to look at harm risked. And there's an argument for that, and it is superficially appealing. But the reality is, it's so difficult to assess. It's so difficult to assess through the court process that we spend our lives working on, that actually you're going to get such different results in a very unfair way. Whereas if you do look at the harm that took place, you do have something to anchor yourself on in the whole enforcement process. And then you can say, okay, but the risk could have been bigger or smaller, but at least we kind of know what happened. And that's how we used to work. We used to know where we were. And I think we've lost that benefit. And actually, we are in a much less consistent sentencing world, much harder to guess or to advise a client where we are. I mean, let's give you real examples. I advise clients, you've had an accident, what's your likelihood of harm? I would be relatively precise before this February in saying, I think if this comes to court, you'll be fined between £100,000 and £200,000. And now I find myself advising clients on similar incidents. Well, I'm following all this stuff through, I'm really following it through carefully in the guidelines. I think you could, if things go well, be fined £50,000. And if it goes badly, because you're a big turnover company, you could be fined £10 million. And they say, you're mad. And I say, well, yes, it is mad. I'm an experienced lawyer in the field, and I'm saying this is what happened. You could be fined between this small amount and this huge amount. What kind of guidance is that? But I'm following this stuff through. It is really not creating a consistent approach that it thinks it is.
We'll still take some questions, though the studio will have to help me out here because the iPad is locked. Mike, is there anything in the pipeline that we should look to? Any cases coming up that you think are going to add any more clarity or? Well,
I'm not sure there's any more clarity that's going to be added, but I think that everyone's eyes is on the Alton Towers prosecution, which is the one last year with the Smiler ride and the terrible injuries that 5 people sustained. When that case, we haven't yet had the sentence in that, but the company has pleaded guilty. That's Merlin Attractions. And I think it was at the Magistrates Court when they sent it up to the Crown Court, said, this is a case of very high culpability. So a very large turnover company and high culpability. So I think it will be interesting to see how that sentence comes out. And because it's so high profile, we might actually get some more details of what the judge says.
I think it's important to realise this is really early days. This came in February. We're now at the beginning of July. So it's going to take a few years before various cases work their way through. And the other thing that's kind of skews the picture is, I don't know about you, Mike, but all of our cases we were trying to push through as soon as we could before February to get in under the old regime. So there were lots of fairly big cases that we were just pushing through to get in before. So that's also sort of put things out of sequence. But bit by bit, Alton Towers we're going to learn a lot from, I'm sure.
Yeah.
One of the questions that's come in is on turnover. Actually, there's a couple on turnover. One is there any provision for a company that has decent turnover but no profit? And the other is how is turnover calculated for a UK entity that's owned by a US parent? Should we start with the first of those? If there's no profit, but
well, if there's no profit, I mean, there's a few things to say. I mean, there were cases that went before. I think one was RNS, which it talked about, the ability to be able to pay.
Mm-hmm.
And there is also the provision, and when you go through the guidance, there's I can't remember which step it is now, but this thing is of step back. You step back and look and see that that this is proportionate, this is fair. One would hope that if you made the submission, well, look, our turnover may be this, but
No, there is something in the guide. Profit can be taken into account, but it's very much at the later stages of things. So, and one needs to understand, two companies, one's profitable, one's loss-making, but they're both similar scales by way of turnover. The decision-making in creating these guidelines is, whilst profit might exceptionally be taken into account to moderate the fine, ultimately that's not the key. That shouldn't be taken massively into account. You can't escape by being loss-making, you can't escape your culpability if you're a big organisation.
I mean, the way to get around it, which is in the guidance and it's started to happen in the last 3, 4, 5 years, is the judge will say to the company, well, let's look at your assets, look what you've got, let's look, what really are you worth? And then to start saying, well, okay, the fine should be X because that's what the case warrants, right? I appreciate your circumstances, and then give time to pay. I mean, I've had cases where the client has been given 3, 4 years to be able to pay the fine and the costs, and and then it's done in instalments. And I think that is the way that they will go, rather than look at and say, oh well, your profit is small. Is to say, let's look at the time you need to pay.
Sure. There have been discussions as to whether this whole process should be based on profit rather than turnover.
Yeah.
But I tend to agree that turnover is a better model than profit as your starting point to work this process through, because it's to do with the scale of your organisation, your turnover. But it can create some ludicrous results, because you could have a 2-person organisation and with a massive turnover, because your business is taking commission, like a credit card might take commission on sales, for example. Mm-hmm. So you could be a massive turnover corporate with 2 employees, and one of your employees falls off a chair. But you will be taken as being one of these mega turnover companies, even though your profit might be very small, because you only might take 0.01% as a margin, because that's the nature of your business. But you'll be compared with a major employer like a car manufacturer or something in terms of culpability. So it can go very badly wrong. But I think it's better to look at turnover than profit. And on that question about the Americans, it's important to appreciate, starting point, look at who is the defendant, who is coming up for sentence. The who is usually going to be a corporate. What is the corporate entity that is being sentenced? What is the turnover of that corporate entity? Unless that is exceptionally giving the wrong result, the court will just look at that. But if it is exceptionally giving the wrong result, because actually all of the activities takes place with a sister company or an American parent company, and it distorts the picture, then the court can look beyond that company to another company. I think that's fair, and I think a lot of people make a lot of fuss about this and say, oh, this is terribly unfair, it's really confusing. I think you just go with the flow on this one. You look at the corporate, and if that creates an unfair result, go elsewhere, otherwise you don't. Sure. And I think that's how the Balfour-Beatty case was looked at in the end.
That's right. I mean, I think the reality is in the old days, when you had a large company, they would look at, what's a reasonable fine, and wouldn't make any interrogation of the finances. What the movement, in the last, I suppose, 5 to 10 years, which is confirmed in the guidance, is that, as Simon says, if necessary, they will go beyond the defendant, but the starting place and is to look at the defendant corporate accounts. And I think you're right. I think we both agree it's only in exceptional circumstances will they go beyond.
We'll come on to implications for individuals in a second, but another question that's come up is how do they apply to public sector bodies?
Well, that's an interesting one, because of course a local authority has an enormous turnover. Well, a lot of them do, particularly the Birmingham City Council, I think is one example, absolutely massive turnover. So on these measures, they will be taken to the very high echelons of these scales. And the answer is, there is something in the guidelines which says something like if there would be an impact on public services, or if it's a public type body, that should be used to moderate the level of the penalty. But it'll be interesting because they'll still be taken as a starting point to those big levels dictated by their turnover, and that will lead the judge to these very high fines. And then I suspect the judge will moderate it. But say, for example, they're taken to a £10 million fine, and then they say, right, but you're Birmingham City Council, aren't you? So it's not really very fair. This is just going to affect the council taxpayers and your ability to do all your other public services. So I'm going to moderate the £10 million fine. But what's the judge going to do? I don't know. We don't know. Maybe say I'll slash it by 50%, slash it by 70%. You still get quite a big fine that you wouldn't otherwise have got. And the same is going to apply to charities. It's the same kind of thinking. Charity comes up for sentencing. Charities have enormous turnovers, some of them, very big turnovers. They'll be starting at these very high levels, and then they'll say, yes, but what's the implications? And the judge could say, okay, well, instead of 10 million, 3 million. But that 3 million is masses more than they would have got in the old system. But I guess that's...
But I mean, in the guidance, it talks at it tells you for each type of body, the type of financial information that you're going to be looking at. So, that's the starting point. So looking the guidance for the particular type of body that you have for the financial.
Sure. In another question was that, and we had discussed this earlier, do you believe that the Scottish courts will use these guidelines as persuasive? There is already a case, isn't there, a Scottish Power, where the judge referred to the guidelines even though they don't apply in Scotland.
That's right. I mean, if you look back to the start of the Health and Safety at Work Act, the very early cases, determining what certain parts of it, what it meant, were Scottish cases, and in the UK courts we relied on them. And as time has gone on, north and south of the border, we've looked to each other's cases. I think there is, I couldn't remember the name of it when we were speaking earlier, but I think there is a criminal case, not to do with health and safety, but a criminal case in the Scottish courts, which says that you can look at sentencing, you can look at guidance in the English courts. So I think the reality is that they will look at the guidance in the English courts and apply as they think appropriate.
Until or unless they get something for their own jurisdiction. Okay. Simon, could you say something about the guidelines application to individuals?
Yes, I think discussions like the one we've had are tending to focus on the corporates. And the corporates have the bigger voice. But actually, and although I'm indicating that I think the guidelines are taking us to a very strange and I think incorrect position for corporates, for individuals it's really very much worse.
Yeah.
And this remains to, this hasn't really worked through. There's a slide.
I think the problem is that it's the big fines that has been getting there's been the noise and there's been the publicity about. Not so much the impact on the individual, and as you've said before, Simon, it's lowering the bar for
this. One needs to forensically look at. If you have a look at the next slide,
I think that's the end of the slide. I think we go back to the.
No, we've got one. So this is I think the last slide.
Sorry.
Right. So okay. So we have a similar system to individuals as the one I explained for corporates. It's not exactly the same, but it's very similar. First of all, for an individual, you're now coming up for sentencing. You've been convicted or you've pleaded guilty as an individual for a health and safety offence. You might be a director, any employee, senior executive. You're coming up for sentencing. You've got a maximum penalty of 2 years in jail for a health and safety breach or an unlimited fine, and the judge has to decide where to put you on this scale between fines and jail of 2 years. And starts with what's your culpability, with all those factors very similar to we saw before. Looks at a matrix between the risk of harm you've exposed people to, the likelihood of harm, decides on a harm category, feeds that into one table. This is the table on the screen. And then the judge has to read across on this table where you come and follow this table. And as you'll see, I've highlighted in yellow the more serious cases where the judge is effectively being told you've got to send this person to jail or give them a prison sentence. Yeah? So, and of course, quite sensibly, as you would expect, it's only the more serious cases that come into the category. If you look at the lower cases, there's fines, smaller fines, community service orders, and then the more serious cases has the jail. Okay, that sounds very sensible, but this is the problem. Those same inflationary factors that I mentioned, do you remember I talked about exposing people to risk? They may only have broken an ankle or not been injured at all, but it's as if they were paralyzed. Yes? You've exposed more than one person to risk. You get jumped up a category. Those factors are at work on this table. So on the face of it, it's superficially fair and sensible that the most serious cases would get the jail time. But that's assuming that if you did 100 cases, they would be spread evenly throughout this table. But if I'm right about these inflationary factors, if you look at 100 people who come to trial, more and more of them will be sucked into those higher categories because of the way this regime has been created, in my view, in error. So we wait to see. It's really too early to see how it's going to come through. But what I anticipate as the result of this is that many more people who've exposed people to risk but end up being prosecuted as individuals will find themselves in jail for health and safety offences that we would, as professionals in the business, we would not ordinarily have expected that they've done something serious enough to end in jail. But this is what's going to happen because of this regime. So for directors, senior executives, becomes very important because they can easily become the people who expose people to risk because of decisions they've taken or things they haven't done. And suddenly, if they do get prosecuted, they get sucked into this regime.
Sure. There are two more sets of guidelines that will affect sentencing in this area on the stocks.
Yes, so this is not the end of the story. So I've got, there's this one here. This is the one we've been talking about. That's the health and safety offences. So what's coming up next? There's one that looks tremendously similar, but that's just because it comes from the Sentencing Council. This is for all crimes, not directed at health and safety criminal stuff. If you plead guilty, under the current rules, if you plead guilty at the earliest reasonable opportunity, you'd expect a discount of 1/3 on your fine. And in the old days, we sound like old men talking about the old days, in the old regime, we would expect, I don't know, 80% of cases, maybe 90% of cases would plead guilty quite early, would get the benefit of this 1/3 discount. The new rules that they're consulting upon, that I've been lobbying against, say that that 1/3 discount only comes if you enter your guilty plea at the very first time you're in court and you're asked how are you going to plead. And you don't have a discretion to delay that period because, for example, I can't plead yet because the prosecution haven't said how they view my case. I can't plead yet because the prosecution have not managed to even tell me, is this a high culpability or low culpability? Do they think it's the top harm category or the bottom? The prosecution haven't told me yet. Do they think I'm going to jail or I'm just going to get a £50 fine? But you've still got to make your decision at that very first opportunity. Now I'm hoping that the Sentencing Council will moderate what was in the draft they've produced, but if they don't, we will find that far from most cases pleading early enough to get the 1/3 discount, most cases under these new rules will not plead on time. And so what's the opposite of a 1/3 discount? I think, if my maths is right, it's a 50% uplift. So inadvertently, what we may see, this may come in November. I'm hoping it won't be drafted as the current draft, but if it does come in, we'll effectively see another 50% on top of the punishments for most people because of these guidelines. And then there's another guideline coming in, which is being worked upon after this. It's like the buses coming in a bunch, which is looking at manslaughter, sentencing for manslaughter, the crime of manslaughter, generally, which will include gross negligence manslaughter, which is the one we're familiar with in the health and safety world. And so this will look at how long should be the jail term for gross negligence manslaughter, which I think at the moment has been hovering between 2 and 4 years. We've had 2 cases of 6 years recently, but I think the intention will be that more of those cases will be up at the higher end for health and safety type gross negligence.
I think it has to be because of the sentencing for health and safety.
Yes.
You know, if it's 2 years, you know, it's got to be above. You know,
Well,
2 years is the maximum for a health and safety offence.
That's the intention of
it's got to be greater for manslaughter. I mean, I think going back to your, you know, the early guilty plea. I mean, I think one of the things there is, I mean, as you say, this is for, you know, crime in general, isn't it? But it does have a big impact on health and safety. And I think that this move is all part of the current move in criminal work, which is, you know, the courts want to see defendants plead guilty early if they're going to plead. And the problem for health and safety is the facts of a case invariably, I think, is fair to say.
Well, more than ever now. We're in this new world where those little details about whether you're going to fall off a ledge and how serious it's going to be and how high it was and all the rest of it determines the difference between a £50,000 and a £10 million fine. And yet you're supposed to decide in this new world to get your 1/3 discount how you're going to plead when you don't even know what the prosecution say, how they're putting the case.
Yeah, because it comes down, you know, health and safety is so much about the interpretation of the facts and how you view it, how you assess it.
I suppose it's because when they created these rules, it's just based on, look, you're a burglar, you went into that house to steal, you know whether you should plead guilty or not. Don't come up with silliness and delays. You decide at the earliest opportunity, this is how I should plead. You should plead guilty at the beginning, otherwise you don't get the discount. So that's the rules that are being set with that mindset, and they're not, but health and safety is a much subtler game.
Yeah, and I think, you know, what it does is with that and the other changes that are occurring in the criminal courts, to make the defence, to put the defence on in the position of having to play their case earlier, having to say what the issues are. It means that, you know, when you have an incident, as we all know, you don't get, you know, it might be a couple of years before you're prosecuted. It does mean that you've got to start looking at the case earlier on. You've got to start thinking possibly about experts earlier on who might be, you know, you've got to just, because, you know, once the case starts, the sausage machine starts, you're going to be asked to do a lot of decisions earlier on. Sure. And I think that's, if you like, the big changes is really that's coming along to our world.
It's a completely different way to handle a case.
Yeah.
First of all, you have to front load your work.
Absolutely.
Secondly, you have to get experts in, because you don't get that much time with your experts. You have to start thinking about experts and speaking to them before the charges arise, whilst the investigation's ongoing. You have to think much more carefully about having, dare I say it, lawyers who are really going to be specialists who understand what's going on here. Because the difference between a case being handled well and badly is now, you see, in the old days, the difference between handling a case well or badly might be between a £200,000 fine or a £300,000 fine. Now, each of those category steps of culpability or harm category can have a value attributed to them of £1 million. So every little thing I can do for a client to do a better job than they might otherwise be getting might be saving them £1 million. And that leads us quite often now into advising clients they need to fight at trial, because we've got a shot at it in front of the judge to convince, even if we lose at trial, if we convince the judge that we're not very high culpability, we're medium culpability, if that's all I can achieve for a client, I can save them £2 million. So why would you just go in straight away pleading guilty? And why would you rush at it and use an approach which is do the minimum amount of work. We've now got a different cost effectiveness as to whether we fight a case, think about it seriously, or just plead guilty quickly.
Just to stress, that is for larger organisations. The kind of £1 million risk or £1 or £2 million risk in different culpability levels is for the larger organisations.
The same features apply, but you're absolutely right. The smaller organisations, the differences are not as extreme. That's absolutely right. But actually, even at the middle scale, there are big differences that need to be carefully thought about.
I do think, irrespective of the size of your company, you want to be put in the best position, if a prosecution comes. And, there's lots of other stages before prosecution starts, like now you're asked to put submissions in by HSE. I think, a little bit of time doing a little bit of investigation early on to understand what the circumstances are, and also to think not just about collecting evidence, but how would I present that at court, doesn't actually increase a lot of costs at the beginning, but puts you in a much more informed position should you be prosecuted.
Just to say that for those of you who'd only booked out an hour for this, we will carry on because I think there's a lot more to talk about. And if you have to go, then you can come back and see a recording of this at any time with an enhanced slide deck, which is all you can download and view along with the recording, which will be hosted for I think the next 6 months at least on the web. But we've already moved into, I suppose, what a lot of duty holders will see as the most important thing, which is what can they do to safeguard themselves against ending up in the position where they're faced with high hundreds or £1 million fines?
Yeah, I think there are some really important things that I help my clients do, and I'm sure you do very similarly. The first thing is training and understanding for the directors and senior executives. I think we can add a lot to help the directors understand the importance of setting the right tone at the top. It's the vital message, and we can illustrate the message by looking at what are the implications through the sentencing guidelines of how your decisions are going to impact, how it goes wrong. So there's that sort of face-to-face training, or I've created a computer-based training for directors. So there's that sort of thing. The other thing I do quite a lot is a legal review of health and safety policy statements and roles and responsibilities documents. So health and safety professionals and consultants have created very good documents that achieve the aim of reducing the likelihood of an accident happening, but they haven't had a lawyer look at it to say, hold on, there are hostages to fortune in the way you've created that. And tweaks need to be made to those documents that in my experience have usually not been made, where when it does go wrong, the way those documents are drafted, if you don't moderate some of the language in it, can get people into jail, particularly in the new regime. And then the other thing where as lawyers we can add value is to explain what you do, is to explain in advance of an accident what you should be doing when an accident happens by way of incident investigation, in order to protect the investigation report, which needs to be protected by legal privilege. Otherwise it can be a very bad hostage to fortune, which can be used against a defendant unnecessarily by the prosecutors. And there's a procedure you can work into your documented regime for dealing with accidents that can get you this really important protection, a very important one to have.
I think you're absolutely right, Simon. I mean, going on to the accident report, I think it's more than just trying to get legal privilege. I think that so often I see with clients is that, understandably, they have a process for doing reports, that they have a structure. But sometimes you look at that structure and you think, we've ended up with a 20-page, 30-page, 40-page report about something that's really quite simple, but simply because they are stuck into that structure. And what you've got to bear in mind is if that report ends up in front of the jury, which it may do, you in that particular company may understand what you're talking about in the terms of the language that you use. But, people will just gloss over. It's really got to be user-friendly. I know some companies sort of kick back on that because they think, well, this is for our business. Yes, it is. But even if it's for your business, the people that are sitting around the table looking at that particular incident now may not be the same people who have to review it in 5 years' time. So, communication and the way you communicate within that report, I think is very, very important. And the other thing is when you look at recommendations within the report, there is this thing of where, there is this need, there is this feel, because something is terrible has happened, we ought to make lots of recommendations. And one thing I say to companies is, the more recommendations I see in the report, the less confidence that I have you actually understand what went wrong and how you can, improve things. But the other thing is, supposing you've got a work process that's been in place for 10 years and it's the first type of incident you have, the first thing is, why are we looking to change it? Sometimes the most obvious, the do nothing option, is not considered because somehow it's thought that that cannot be right. The other thing is you see recommendations put in place, and the recommendations, there's not a period on there to review to see if they actually achieve what you think they are going to achieve. And another thing is that you see the people that are investigating don't actually talk to the operations properly. Because the operations may be able to say, oh yeah, well I remember when Charlie did such and such. That's why we didn't do what you're telling us to do. And sometimes you do feel that there's an investigation report, and because we've got to do one, we've got to have it right. And this is where what Simon says, by having legal privilege over it, you have a chance to, everyone reacts. Don't underestimate how a death or a serious accident can affect the morale of not only the people on the shop floor of a company, but also the people that run it. And sometimes, what seemed like a good idea at the time for changing things, a little, in the cold light of day when the dust has settled, may not be, the best thing. So, that's something I would urge. And I also, when you are there at the beginning, sometimes, having a thought about the case, talking to the people that are involved, the people that manage these things, sometimes gives you a much better insight, I think, Simon, doesn't it, into the operations or whatever, if you do it early on rather than wait.
I think that what's interesting here is that there's often a perception that as lawyers, with the privilege protection over these investigation reports, we're trying to hamper an investigation. And for me, the message is really one of, I like my clients to do a privileged investigation report, but now it's in a private dialogue with the lawyer. They can actually feel free to go and do more of a warts and all investigation to learn whatever lessons they want to learn, without the strange feeling, particularly with a serious accident, that they don't quite know whether they should put the damaging findings into their report because they don't know who's going to read it. The answer is the court will read it because it's routine for the enforcement authorities, HSE, local authorities, routine to request a copy of an investigation report, and they have the powers to demand it, and they will demand it. It's routine to refer to it in the prosecution, and then it completely damns you. There's no way out of it. Very difficult, particularly if you've changed your mind. Well, 2 weeks into the accident, we thought we'd done this wrong. Now, 3 years later, when we've got a £10 million fine hanging over us, actually we've got a slightly different view. But it's very difficult, and we've struggled to dig our clients out of a hole. But we don't need to go into that hole if we just have that private dialogue, still do the investigation, still produce a report, identify your failings, and I don't tend to interfere with what those findings are going to be. I just want to get it into that private dialogue which has this legal word privilege. I don't think you should interfere,
but you should act as a facilitator to make sure that everyone's sitting around the table who ought to be sitting around the table. The other thing, which is, just to make it clear, is that what Simon's saying is if it's legally privileged, then the authorities are not allowed under the rules to have a copy. Doesn't mean to say that you can't release it later on, but when, as I say, you've had more chance to consider it, you've had more. And the other thing to think about is, sometimes, particularly the bigger companies, will go out looking for expert advice once an incident occurred. You know, the thing is, the same rules apply. Make sure if you are going to instruct an expert because you think it's important for your business, that you're actually getting the right person. You've got the right. I've had, you know, cases in the past where a client has thought they've gone to an industry expert for that, but actually that expert doesn't do what they do, and so he's not in a good position to advise. And the other thing is that they assume, which is, well, I'll just hand over all the papers and they will tell me. You know, you've got to give them a remit of what your concern is, where you're looking, you know. So it's not straightforward, and sometimes, you know, what you do is you need someone, I think, sitting from the outside like we do, acting as a facilitator and as sometimes a sounding board.
Presumably, if we're talking about trying to avoid people getting into the situation where they risk an enormous fine, if you go back up the kind of hierarchy of controls in this area, then you'd look at if there was any area as a someone responsible for OSH in an organisation, you had a sense that you might have any weaknesses, you'd put those in front of the board with a request for funding using the fines to date as ammunition.
That will concentrate their minds. But I mean, another thing to think about, and as Simon was saying, the importance of talking to directors and whatever. One of the things, you know, that I find often very interesting is, you know, directors can be operating in all good faith on the information that they are provided. You know, sometimes you challenge them and say, what makes you think you've got the right KPIs? You know, sometimes you find that, you know, larger organisations is that you've got the guys on the ground telling the middle management what they think, but the middle management reporting up as to what they think the guys at the top want to think. And sometimes it can be a matter of people at the top just getting out on the shop floor to see whether what's being reported to them.
Well, that's the message. That's why we like to talk to the directors and assist the heads of safety to deliver that message. We're kind of, you know, we can help the delivery of them understanding why it's so important for them to be proactive on safety. That's, you know, that's what we offer, really. That's why we try and help.
And I think, you know, for the vast majority of companies, you know, well-managed companies manage safety well. That's the reality, and they want to do their best because it's good for the business, you know. And sometimes, you know, okay, you're giving them advice and whatever, but is then just getting, well, what's your experiences in other industries? What are your thoughts? What have you found? You know, that sometimes can be useful to them in thinking about the way they manage their own business.
There's a question come in on civil awards. Do you think that there's likely to be any increase in awards in civil cases as a bleed through from the effect of the guidelines?
I think it unlikely, because that's a separate.
Yeah, I think it's really important to distinguish civil from criminal, and the two are separate. No, I don't see any read through.
Sure. One I was going to ask. Would you like to hazard a guess as to what turnover level marks out a very large organisation?
It says more than £50 million. In fact, what's the actual wording? Is it more or significantly more? If you have a turnover of £100 million, you are, let's get the exact wording, if your turnover or equivalent very greatly exceeds £50 million. So, if you're £100 million, do you very greatly exceed 50 million? Yes, by 50 million. If you're £80 million, do you very greatly exceed 50 million? Well, 30 million is quite a lot. I don't know. We don't quite know. But I would have thought, in my way of thinking, once you're at 100 million, it's quite difficult to say you don't very greatly exceed 50 million. Because, of course, all the other scales lead up to this 50 million. But we don't know. We wait to see this. And the interesting thing is everyone says, oh, well, let's wait and see what the courts make of answering these questions. But unless it's a court of appeal decision, the Crown Court judges deciding these things aren't going to have influence on the next judge. The next judge along the way shouldn't really be listening to what the previous Crown Court judges say. He or she should be looking at these guidelines. So only certain tweaks around the edges of interpretation will come up to the Court of Appeal as things go through. But don't sit there hoping that the judges are going to change this and moderate it. It is what it is. You have to interpret it as best you can. I mean, I'm hatching a plan that in 2 or 3 years' time I'm going to be gathering enough evidence together to request tweaks and changes to this, some of the sorts of things that I've been mentioning. And I want to be doing research. You mentioned earlier, Mike, that it's really difficult because you only get what the HSE have reported. And I'm planning to grab people together and do some proper sucking out of some real information, getting the transcripts of the judge's sentencing remarks, trying to really understand what's gone on in these sentencing, trying to pull it together, analyse it, and put a case that perhaps, if it's as I foresee it being, perhaps this stuff needs to be moderated and some of the language needs to change. So that's my project for the next 3 years in a role I do for the Health and Safety Lawyers Association. But we wait and see.
There was some talk before the guidelines came in about the kind of incentives they might give to organisations to restructure in order to rebase the profits of any part of the organisation, or the turnover of any part of the organisation. Someone's asked about whether that seems to be, whether you see any evidence of that happening, and someone else asked about Phoenix companies, the problems of Phoenix companies, and whether there's anything in train to try and stop penalty avoidance techniques.
I think the restructuring issues, in the past I've always said it's like the tail wagging the dog if you're going to organise your corporate structure for health and safety. But now I think, and I'm advising clients, we do have to think in a more intelligent way. I mentioned that we look at the corporate itself, and that's the main thing, and its turnover. Say you're an organisation with £100 million turnover, and and you're one corporate, and one part of your business is the bit that generates the hazard, because it's the bit. Yeah, so we got that, and that might have a £5 million turnover. I think you do now need to seriously consider, well, why don't we just take that division, put it in a separate corporate, so we can protect our main £95 million turnover business, take away the most hazardous part into another business. Those are the sorts of things we do need to think about now. And I'm starting to advise clients on, and they are interested in it. I think it would be foolish to ignore it. It doesn't mean that in every business it's appropriate to slice it up. But you might, if you're a construction company with a £100 million turnover in 5 different parts of the country, operating from 5 divisions, you might now think, well, we are high hazard. Let's split ourselves into 5 corporates. Each division can now be a subsidiary company. Maybe that works. If it works otherwise for tax reasons, or doesn't have a bad impact for tax and organisational reasons, then certainly for health and safety reasons in a hazardous industry, you'd very much think of those sorts of things.
Thank you.
What was it? And the Phoenix, do you want to deal with the Phoenix?
Well, I think the Phoenix one is that you know, at the end of the day, as Simon was saying, the company that's being prosecuted is the company that is being fined. You know, and unless you get to a position where you're talking about piercing the corporate veil, I can't see that there's anything in the guidance that gets you around that.
There's this very interesting interplay. When you have a company that is clearly likely to be on the way out, it's a relatively small company, they've had a serious accident, they're being investigated and facing prosecution. The directors have decisions to make about whether the company can continue, and they might think, oh, it'll be a convenient thing, let the company go into liquidation, then it doesn't really matter what the fine is going to be because it's never going to be paid, or however it works. The individuals have to watch out, because if you're a prosecutor and you think it's going to be a waste of time going against this company that's disappearing, that's the time when you say, I think I'm going to prosecute the directors. So, and remember I've said the directors may be more likely to go to jail, so the directors are going to be in a difficult bind if they think by letting the company disappear, that's going to get them off the hook. It might actually put them on the hook. So different things at play now.
And also, you know, you may
gloss for the viewers that Phoenix companies are those which facing a prosecution that close down and then re-emerge with the same as a new company with that cannot be prosecuted with the same directors. Just for those
rising from the ashes.
Yes.
I think the other thing to say is if it's part of a bigger bigger organisation, your points, about splitting capital, is you could get a prosecutor saying, well, okay, that's the company that's got that hazardous part, but how's the rest of the group? What are they setting out? How are they managing, influencing that risk? So you might see, I'm not saying it definitely will happen, but you might see prosecutors looking, wider, asking questions of other parts of the group. So that's a potential.
There's been a lot of people asking about the public sector and charities, and I know we covered this earlier, but I thought there was an interesting point where you had said that, Simon, that Birmingham City Council has a massive turnover, parking fines, council tax presumably. What about an NHS trust? How will the courts look at calculating the turnover of different types of public bodies?
It's precisely the same point. The turnover will be that there's an accounting exercise, but all these bodies have turnovers. A local authority and an NHS trust, they have a turnover. To do with I'm not an accountant. There is a figure, and that's there. And that figure will, in many cases, take them into the very highest aspects of these tables.
But will that include government funding as
Yes.
turnover?
Yes.
So any income that they receive
Yes.
to
They're
operate
is they're the biggest organisations in the country.
Well, yes.
Local authorities and some of the biggest charities as well, the well-known charities. So they're in massive figures. Now, they'll be the way this exercise works is they're taken through the table, but then they can be moderated to take into account of the public good they wouldn't otherwise do if the money was taken away in a fine. So of course the charities will throw that in, and of course the judges will moderate it. But if you're the judge with a big national charity and your first cut takes you to, this is a £10 million fine, you're then asked, okay, I will moderate it. But does he or she moderate it down to £50,000 or down to 1 million? Because it's quite tricky for the judge to take it completely off the scale. And we'll wait and see how that happens.
But if you go into the guidance in terms of the information, it sets out the guidance on page 6. I mean, for local authorities, what they'll be looking at is the annual review budget. For health trusts, it's the NHS Foundation Trustees Monitor, so that's the group. And that publishes quarterly reports and annual figures for the financial strength and stability of trusts from which the annual income can be seen. So that's, it is set out in there, the figures. But as you say, the figures are the figures.
I think do you think there's anything more that we should have covered in this session? I think we've covered off most of the grouping, the questions. I think we've covered most of those. There's a couple of extra ones that I think we could come back to separately in writing, and we'll put them on the end of the slide deck for anyone to download afterwards. As I say, the whole of the slide deck, an extended version from what we saw today, and this recording will be available on the IOSH Magazine website for the next 6 months at least. But is there anything more before we go that either of you think we should have covered?
No, I think we've covered an awful lot of ground in about an hour and a half, haven't we? So,
yes.
But as you say, if there are questions, then Simon and I will do our best to answer them.
Yes.
Simon?
Yes, well, thanks for inviting us along.
Yes, thank you.
Oh, well, thank you. Simon Joyston-Bechal, Michael Appleby, all of you for viewing. Thanks very much for attending the IOSH Magazine webinar.